Hello! Welcome to the Civil Harassment page of the ULV Justice Center website. Before I begin, I would like to make it clear that the information provided on this site is not legal advice, but is provided for informational purposes only. If you're in need of legal advice, we advise you consult with an attorney. Also, if you've not done so already, please print and download the Civil Harassment Study Aid to interactively follow the video. Let us begin. So what is civil harassment? In general, civil harassment is abuse, threats of abuse, stalking, sexual assault, or serious harassment by someone you have not dated and do not have a close relationship with. The law states harassment is unlawful violence such as assault or battery, stalking, or a real threat of violence with no valid reason for it. If you or a loved one are experiencing harassment and you feel scared or seriously annoyed, you may qualify for a civil harassment restraining order. Who qualifies for a civil harassment restraining order? You can ask for a civil harassment restraining order if a person has abused or threatened to abuse, sexually assaulted, stalked, or seriously harassed you. The harassment you are experiencing must be from a neighbor, roommate, friend, someone you don't know, a family member such as an aunt, uncle, or distant relative for you to be able to request a civil harassment restraining order. You may be wondering, what if I don't qualify for a civil harassment restraining order? If you or someone you know do not qualify for a civil harassment restraining order, there are other orders you can request that could be a better fit for you, such as domestic violence restraining order. This is for protection from people you're involved with romantically at some point or close family members. Elder or dependent adult abuse restraining order. This is if the person being abused is 65 or older or between 18 and 64 and is a dependent adult. Workplace violence restraining order. This is filed by an employer to protect an employee from violence, from stalking or harassment by another person. If you're not familiar with restraining orders, you may be thinking, what can a restraining order do? A restraining order is a court order. It can order the restrained person to not contact you or any member of your household, not go near you, your children, or others who live with you no matter where you go. It also orders the restrained person to stay away from your work, your school, or your children's school, and to not have a gun. Once the court issues a restraining order, it goes into a statewide computer system. This means that law enforcement officers across California can see there is a restraining order in place. If the person to be restrained violates a restraining order, he or she may go to jail, pay a fine, or both. What types of civil harassment restraining orders are there? There are different types of restraining orders you may ask for. They are emergency protective order, temporary restraining order, permanent restraining order, or a criminal protective order. Emergency protective order. Emergency protective order, or also known as the EPO, is a type of restraining order that only law enforcement can ask for by calling a judge. Judges are available to issue EPOs 24 hours a day. So a police officer that answers a call because of serious violence or a serious threat can ask a judge for an emergency protective order at any time of the day or night. For civil harassment cases, EPOs are only available in cases of stalking. If you are being stalked, you can call the police and ask for an EPO. The emergency protective order starts immediately and can last up to 7 days. The judge can order the abusive person to leave the home, if they live with you, and stay away from you for up to a week. That gives you enough time to go to the court to file for a temporary restraining order. To get a more permanent order, you must first ask the court for a temporary restraining order. Temporary restraining order. Temporary restraining order, or also known as a TRO, is what you will be issued before a permanent restraining order. To file for a TRO, you will have to go to the court to ask for a civil harassment restraining order. You will fill out paperwork where you tell the judge everything that has happened and why you need a restraining order. If the judge believes you need protection, he or she will give you a temporary restraining order. Temporary restraining orders usually last about 20 to 25 days until the court hearing date. Permanent restraining order. You can only get a permanent restraining order when you go to court for the hearing that was scheduled for your TRO. The judge may issue a permanent restraining order if they feel like it is needed. These restraining orders are not really permanent because they usually last up to 5 years. After the 5 years, you will have to renew your restraining order. Criminal protective order. You can also be issued a criminal protective order, also known as a stay-away order. Sometimes, when there is an incident of violence or severe harassment, the district attorney will file criminal charges against the person committing the violence. This starts a criminal court case. It is common for the criminal court to issue criminal protective orders against a defendant, which is the person who is committing the violence or abuse. This type of order is effective while the criminal case is going on, and if the defendant is found guilty or pleads guilty, can last 3 years after the case is over. What are the steps to obtaining a restraining order? There are a series of steps you will have to complete in order to obtain a restraining order. Step 1. Fill out your restraining order forms and file with the court. If you're asking for protection, you must fill out the required civil harassment forms and take them to your court clerk. The clerk will let you know what to do next. In some courts, the clerk will give all your forms to the judge. In other courts, you may have to go to the courtroom directly. Either way, the judge will read your papers, maybe speak to you, and make a decision on whether or not to make the orders you are seeking for. If you leave your forms with the clerk, ask the clerk when to return to see if the judge made the orders you asked for. The judge must decide by the next business day, but the exact time varies from court to court. You can find all required forms on the ULV Justice Center website. The following forms are required to be filled and filed with the court clerk. Request for civil harassment restraining orders. This form is to start the court case to get a civil harassment restraining order. In this form, you'll be providing basic information and asked a series of questions of how you were harassed. Confidential CLETS information, short for California Law Enforcement Telecommunication System. This form must be filled out when you file for a restraining order. It gives information about your case to all law enforcement agencies through a computerized database. Notice of court hearing. This form is to be filled out and filed with the court. The court will use this form to schedule your court hearing. Temporary restraining order. This form will tell you which, if any, temporary restraining orders the judge signed. Civil case cover sheet. Not all courts require a civil case cover sheet, so before filing, ask your court clerk if you need this form. This form gives information about your case to all law enforcement agencies through a computerized database. Additional page. This form is only used if you need more space to describe why you need the restraining order. Declaration or attached declaration. These forms are for any statements of witnesses that will support your side of the story. Proof of personal service. This form serves as proof that the person being restrained has been notified of the restraining order. Make sure to keep a copy to file. Step 2. Schedule your court hearing. You must return to the court to pick up your forms and determine if the judge granted your request. If a hearing is granted, the judge will have issued a temporary restraining order. A court hearing will be scheduled for you. Even if the judge did not make all the temporary orders you asked for, you can still go to the court hearing and ask for those orders. The judge may grant them at the court hearing, even if he or she did not grant them as a temporary orders before the hearing. Step 3. Serve the restraining party. The person being restrained must be aware of the court hearing and the restraining order being filed against them. Your forms can be personally served by anyone over 18 years of age who is not involved in your case, such as a friend, a relative, law enforcement, or a professional process server. Have your server fill out a proof of personal service and give it to you so you can file it with the court. This form tells the judge and police that the restrained person received a copy of the order and knows about it. It is very important your server fills out the proof of service correctly. Step 4. Prepare for your court hearing. If an interpreter is needed, make sure you request for an interpreter prior to your hearing, or bring someone that can interpret for you. Take documents that help prove the abuse. Take 2 copies of all documents and filed forms, including the proof of service. Some of the documents that can help your case may be photos, medical or police reports, damaged property, a threatening letter, email, or telephone messages. If you need to ask for an extension on the restraining order and new court hearing date, the following forms will be needed. Fill out a request to continue hearing and items 1 and 2 of an order on request to continue hearing. Have the judge review the forms and sign Form CH-116 at the hearing, or give it to the clerk together with Form CH-115 before the hearing to give to the judge to sign. If not already filed, ask the clerk to file the signed order on request to continue hearing. This form now has your new court date. Attach it to your other court papers and get the restrained person served following the same directions as with the temporary restraining order papers. Make sure your server fills out a proof of personal service and gives it to you. File your proof of personal service. Give a filed copy of Form CH-116 to your local police and to everyone who has a copy of your temporary restraining order. What can I expect during my court hearing? During your hearing, the judge may ask you questions. This is your chance to explain why you need the restraining order. It is important to tell the truth. Speak slowly. You can prepare and read from a list of all the times you felt harassed. The restrained person, or his or her lawyer, may also ask you questions. Give complete answers. And if you do not understand, say, "I don't understand the question." If the restrained person lies in court, wait until he or she finishes talking and then tell the judge. Speak only to the judge unless it is your turn to ask questions. When people are talking to the judge, wait for them to finish. Then you can ask them questions about what they said. At the end of the hearing, the judge will say what the orders are. The judge may give you the orders you asked for, give you some of the orders and not others, not give you any of the orders, or postpone your case and give you a new court date. This means you will have to come back another day. Burden of proof. If you are the party seeking protection, you hold the burden of proving why you need the restraining order. To prove your case, it is essentially any evidence that is clear and convincing that the person being restrained has harassed or threatened you. Examples of what can help prove your case are medical and police reports, photos, videos, and any threatening emails, calls, or texts. This has been an overview of civil harassment. On behalf of the ULV Justice Center, we thank you for watching and hope this is helpful in your legal matters.